זאת גם הזדמנות מבחינתי להודות לזוהר ולהודות לאסף על הארגון של הכנס המצוין הזה. אז קיבלתם, אתם מחזיקים עכשיו ביד דף עם עובדות המקרה של האירוע, אני אגיד אותם בכמה מילים בעברית. I'll say the facts in Hebrew and then we'll switch to English. אז אני אציג את עובדות המקרה בקצרה בעברית ומשם נעבור לאנגלית, המשפט יהיה באנגלית כי חלק מהטוענים דוברי אנגלית. אז כמו שאתם רואים, המקרה שלפנינו עוסק בסכסוך מאוד מעניין בין קרן גידור אקטיביסטית שקוראים לה סיגמה קפיטל, לבין ויז'ן LTD, שזו חברה ציבורית שמפתחת מערכות מקם לרכבים אוטונומיים. לאחר הנפקה מוצלחת בשנת 2022, ויז'ן, החברה, חווה ירידה בביקוש למוצריה, המחיר מניית צונח, היא מתקשה לפתח טכנולוגיות חדשות, ובתגובה הדירקטוריון החל לבחון חלופות אסטרטגיות שונות, ובהן רכישות אפשריות של חברות מתחרות. בתחילת שנת 2026 רוכשת סיגמה קפיטל, זו אותה קרן אקטיביסטית, 9.1% ממניות החברה, ובעצם פותחת במאבק שליטה בדירקטוריון באמצעות הליך שנקרא פרוקסי קונטסט. לטענת הקרן האקטיביסטית, החברה מציגה ביצועים חלשים, וצריך לפעול למחירתה, ובמסגרת זו היא מציעה גם 4 מועמדים לבחירה לדירקטוריון של ויז'ן, שמונה בסך הכל 7 חברים. בעוד המאבק שליטה הזה מתנהל, ויז'ן מתקשרת בהסכם להקמת מיזם משותף, ג'וינט ונצ'ר עם דלטה, שזו חברה טכנולוגית מתחרה. לפי ההסכם, דלטה תחזיק בשליטה במיזם המשותף, תמנה את רוב חברי הדירקטוריון שלו ואת המנכ"ל, ושתי החברות ישלבו את הטכנולוגיות המרכזיות שלהם ביחד, לצורך פיתוח ושיווק של מוצר חדש. לטענת סיגמה, הקרן האקטיביסטית, המיזם נועד בעיקר לבצר את מעמדו של הדירקטוריון ולמנוע מדירקטוריון חדש, אם ייבחר, לקדם את מחירת החברה או חלופות אסטרטגיות אחרות. לכן הקרן האקטיביסטית מבקשת צו מניעה שידחה את השלמת העסקה עד אחרי הבחירות לדירקטוריון. אוקיי, אלה עובדות המקרה. And now we'll switch to English. So let me quickly present the parties and the tribunal. So we'll begin with the honorable judges who will preside over today's proceeding. Judge Hannah Pliner is the Deputy Chief Justice of the Tel Aviv District Court and the head of the Economic Division at Tel Aviv. Judge Kobi Sharvit also serves on the Economic Division of the Tel Aviv District Court. And finally, Professor Michal Barzuza, Professor of Law at University of Virginia School of Law. Now let me present the 2 outstanding teams who will litigate this case. So we'll start with those appearing on behalf of plaintiff, our Dr. Gil Orion, co-head of Fisher Litigation Department and the head of the class action and derivative suits practice. Nirim, advocate Idan Reiter, a member of the litigation group of Fisher, and by the way, a former student of mine, which makes me feel very proud and old at the same time. And together they have vast experience in litigating in Israeli courts. On the other side, appearing on behalf of the defendant, Vision LTD, our advocate Ted Mirvis, you've already heard him, a counsel and a former partner at Vaktel, as well as a lecturer at law at NYU, Tel Aviv University, and other prestigious institutions. And near him, advocate Rachel Silverberg, a partner in Vaktel. Both of them have litigated some of the landmark cases in Delaware. So let's the fun begin. Each side will have 20 minutes for their arguments and then 5 minutes to respond. And then we'll hear the judges. Thank you.
Thank you. Thank you, Kobi.
רגע, גיל, דקה. קודם כל, החלטנו, גם לטובת צופינו בעברית, אנחנו נעשה את זה סימולטנית, אני אדבר עברית, קובי יתרגם או מיכל. אנחנו נקפיד פה על כללי בית המשפט. אתם כבר ישבתם הפוך, חברים, זה מאוד מבלבל אותנו. המבקשים צריכים לשבת מימין לשופט, ואתם משמאל, אבל נסלח לכם, עורך דין אוריון. אנחנו נקפיד על זמנים, זה כן מארצות הברית, 20 minutes עם השעון, טיימר, אנחנו נרשה לעצמנו לשאול שאלות שינוקו מהזמן, זה 20 דקות ברוטו, כולל השאלות שנפלה לכל אחד מכם, ואנחנו באמת מבקשים התנהגות נאותה, לא להתפרץ אחד לדברי השני, והנה חברי השופט שרביט יעשה תרגום קצר ונתחיל.
She said hi. We can continue. I'm sure that you understood, but just in case you said the opposite sides as we're used to in the Israeli courts, but we'll manage.
We took into account the audience, so
yes.
we chose the...
Each side will have 20 minutes for the main part of the pleadings, including the time to respond to questions that we will address each of the parties, and then additional 5 minutes to respond to the other side. Good luck to everyone.
Thank you. First, I would like to apologize before Judge Pliner. I'm used to sit on the left side in the courtroom, so this is why I made a mistake. And I would like to remind the judges that I'm not used to lose a case. Yes. Just keep it in mind. And I would like to open our oral arguments and to mention the fact that we are going to divide the arguments into 2 chapters. The first chapter deals with the issue of shareholder approval, and to the best of our understanding, in this case, shareholder approval is required. And let us start with the facts. The true facts of this case are as follows. During 2025, Vision and Delta engaged in negotiations. Vision decided not to continue the negotiations because Delta insisted that its management would lead the combined entity. And then, after Sigma announced in February 2026 that it would seek to replace 4 of Vision's 7 directors, Vision's board suddenly instructed management to renew discussions with Delta. The board agreed to Delta's demand only when it perceived a threat in the form of the planned removal of most of its members. Now, in these circumstances, most members of the board of directors had a personal interest in the approval of the transaction, and therefore, pursuant to Section 278C, Gimel in Hebrew, approval by the general meeting is required. Under Section 278C of the Companies Law, where a majority of the directors has a personal interest in the approval of an extraordinary transaction, the transaction also requires approval by the general meeting. In Collinson versus Payne, Justice Ronen held as follows: when a special general meeting is scheduled at which the removal of directors from office is proposed, the assumption that the directors have a personal interest is a reasonable one. Now, Vision argues that in Payne, the transaction at issue was not part of the company's business strategy, whereas here, the transaction with Delta was at the heart of Vision's business strategy. This argument is incorrect. Before any threat to the director's tenure arose, Vision's board rejected the transaction with Delta. After a threat to the director's tenure arose, suddenly the board decided to change its position and approve the transaction with Delta. Idan, please.
Now, Vision argues that the directors should not be deemed personally interested simply because a control contest is underway. But the cases it cites, UltraShape and Levy, do not support that proposition here. Start with UltraShape. There, the transaction had already been approved before the directors were aware of any effort to remove them. Here, the opposite is true. The Delta transaction was initially rejected. It was only after Sigma announced its intention to replace most of the board that the directors reserved course and decided to approve it. Levy is no better for Vision. There, the plaintiff owed only 1% of the company's shares, not 9.1% as here, and therefore had no realistic ability to replace directors. Also, their private offering at issue involved only 5% of the company's shares, so it could not have frustrated a shareholder effort to replace the board. Here, by contrast, Sigma posed a real threat, and the Delta transaction could neutralize that threat.
So under these circumstances, it is clear that the directors have a personal interest and shareholder approval is required. Moreover, the transaction with Delta is actually a merger transaction. Although the transaction was artificially labeled as a JV transaction.
Just a second, גיל, אני עוצרת אותך פה כי אתה עובר לנושא אחר, אני מבינה
אם זה מיזוג או לא. I would like to show that shareholder approval is required for other reasons I would like to elaborate on. So,
okay, so continue, but I want to ask before you go to another subject.
Sure. I'll finish this chapter within 2 to 3 minutes. So although the transaction was artificially labeled as a JV transaction, it is in fact a merger transaction. A merger is defined as the transfer of all assets and liability of the target company to the acquiring company, resulting in the dissolution of the target company. Here, the target company is not dissolved, but it loses control over its assets. Vision is granting the new entity an exclusive 20-year license to the CAR-I technology. Delta holds a majority of the voting rights. Delta will appoint a majority of the directors. Delta will appoint the CEO. Vision is losing independent control over its principal asset. As in merger, one party effectively controls the surviving entity. And I guess all of you know the saying, if a transaction walks like a duck and quacks like a duck, it's a duck. Under Section 314 of the Companies Law, a merger transaction requires approval by the general meeting. In addition, this is a transaction in which the company is transferring substantially all of its assets. The transaction with Delta transfers Vision's core business and its CAR-I technology to a JV controlled by Delta, which holds 51.1% and appoints a majority of the directors and the CEO. Vision will remain without independent control over its business. And under Section 271 of the DGCL, when a company transfers all or substantially all of its assets, it must obtain approval by the general meeting. And I would like to mention here the decision in Gimbel versus Signal. It was held there as follows. If the sale is of assets quantitatively vital to the operation of the corporation and substantially affects the existence and purpose of the corporation, then it is beyond the power of the board of directors. When a company carves out its principal asset and grants others the exclusive right to exploit it, this is functionally, actually, a disposition of the company's core asset, not an ordinary collaboration agreement. The determination that Section 271 does not apply would allow companies to circumvent it by labeling the transaction as a JV, as a license, even when the practical result is the transfer of substantially all of the company's assets. Although Israeli law does not contain a provision parallel to Section 271, in light of the importance of Israeli courts attribute to Delaware law, and given the purpose of the section, which is protecting shareholders from transformative changes, the court is respectfully requested to adopt the Delaware framework, and here is my summary. In summary, based on Section 278C, based on Section 314 of the Companies Law, and given the need to protect shareholders from transformative changes, the court is requested to issue an order preventing completion of the transaction because shareholder approval is required.
טוב, אז אני שמחה שחיכיתי לחלק השני, כי דווקא הוא מחזק את השאלה שלי, ואני רוצה רק מראש להגיד, אין בשאלות שלנו כדי להראות שהתקבענו באיזושהי דעה, זאת רק שאלות להבנה, ואותן שאלות גם יופנו, קשות, יופנו גם לצד השני. אז עורך דין אוריון, כיוון שבארץ אנחנו מכירים, זה לא מיזוג ואין הכרח להביא את העניין לאספה הכללית, אנחנו חייבים לבסס עניין אישי. אנחנו רוצים להתעכב על העניין האישי פה, כיוון שמה בעצם מרוויחים הדירקטורים? ההפך, הם הסכימו לוותר על השליטה. ולכן אמרתי, טוב שנתתי לך לחלק השני, הם מתפרקים מהשליטה שלהם, ואני בהומור יגיד, מה הם מרוויחים חוץ מהבורקסים למשך 20 שנה בג'וינט ונצ'ר המשותף. אפשר להגיד דווקא ההפך, שלפני המכתב שבא ואמר להם, תקשרו, אנחנו הולכים להחליף אתכם, אז הם חשבו מתוך הפוזיציה ומתוך העניין האישי שלהם להחזיק את הכיסא. עכשיו הם מוכנים לוותר עליו לטובת החברה, יש כאלה שיאמרו, אז אני רוצה שתחדד לנו את העניין האישי.
Okay, I'll just make it short. Judge Plina said that the main issue as we see it is not 271, which does not exist under Israeli law, neither the issue of the merger, since this transaction does not fall within the definition under the Israeli law, but the main issue is the claim for personal interest. And the specific question that Judge Plina raised was, what is the personal interest of the directors? Why do we see it as an entrenchment if in fact the JV with Delta puts them in a minority position and therefore they lost or they waived the control, which is not typical for the entrenchment. So that's the question of Judge Plina, and I would add my own question. You can answer them both at the same time. What prevents Sigma for replacing those directors within 3 months, and why don't we expect that there would be, if this is a bad transaction, that the JV, there would be a market discipline here, and those directors would lose their position in vision, and so that's it goes to the same issue. We have additional questions with regard to this major issue, but those are the two questions here. And
Judge Barzuza.
So I'll ask if you just the economics of it. Why do you think that selling the company is a better idea for the shareholders than having this joint venture that provides them market power? It's a joint venture with a competitor, so you reduce competition. If you sell the company along, you don't have this benefit. So if you can talk more about that.
In the 8 minutes that I left you.
I guess it's not part of my 20 time.
We can argue about it.
ראשית, אני אשיב בעברית ואחרי זה אקצר באנגלית. אני לא הייתי אומר שאין הסדר של סעיף 271 בדין הישראלי, במובן הזה שאנחנו, אני לא יודע אם אתם מודעים לכך, אבל אנחנו במוק טרייל, ובמוק טרייל אין לי את הביילוז, אבל אני מניח מהיכרותי תקנונים של חברות מהסוג הזה, בדרך כלל יש איזושהי רפלקציה או שיקוף של סעיף 271 בתוך התקנון, ואני מניח שהייתי יכול להסמך על האמור בתקנון, מה עוד שאני חושב שהדין הישראלי פתוח לקונספציות דלווריות, בפרט שבבסיסן עומדת תפיסה שאני חושב שהיא נכונה גם בדין הישראלי, שכאשר עושים טרנספורמציות קרדינליות בחברה, צריך לבעלי המניות להיות say, ואפשר לחשוב על כל מיני אפיקים שדרכם אפשר להחדיר את הקונספציה הזו לדין הישראלי, כמו שקלטנו קונספציות דלווריות רבות אלינו הביתה. ולשאלה השנייה שנסמכת, שיוצאת מנקודת הנחה שאין סעיף 271, אני חושב שהדירקטורים מתרכזים באופן טבעי בעובדה שתפקידם נשמר ב-JV, זאת אומרת הם ימשיכו להיות דירקטורים, הם ימשיכו להשמיע את קולם, הם ימשיכו להשפיע על תהליך קבלת ההחלטות, הם ימשיכו לקבל את שכרם, ואני חושב שמבחינתם המסלול הבטוח ביותר בשביל להמשיך ולאחוז באיזושהי מידה של השפעה, זה דרך כהונה ב-JV, ולשאלתה של השופטת פרופסור או כל תואר אחר ברזוזה, אני אומר שאני חושב שהציפייה של חברי הבורד היא שהם ימלאו את תפקידם בצורה ראויה, נדמה לי שכבוד השופט שרביט שאל את זה, שהם ימלאו את תפקידם בצורה ראויה, ולכן המרקט דיסציפלין לא יפגע בהם בהמשך הדרך. זאת אומרת, אני חושב שהם אוחזים בתפיסה שניתן במסגרת ה-JV לעשות דברים שהם ישרתו בסופו של דבר גם את הפוזיציה שלהם ב-JV. אני מניח שעידן ירצה להוסיף.
גיל, just in English, because let's move to English back. Sure.
I mentioned the fact that Section 271 of Delaware law is not part of Israeli companies law, but I believe that it is reflected in the bylaws of Vision, although we do not have the bylaws because we are in the context of a mock trial. I know bylaws of companies of this sort, and I believe that they have some sort of an arrangement which is similar to Section 271 of Delaware law. And I believe, to the other question I have been asked, that the board members prefer to keep their positions and to be in the JV and to get their salaries and to continue in their position, and any other change would not be in their favor from this point of view.
I think it's also important to mention that according to the agreement, Delta will not be able to influence the positions of director in Vision. I mean, they might be able to fire them from the JV, but not for Vision. And the way they created this JV agreement allows them to keep their seat whatever what. And I think it's also important to mention that in terms of entrenchment.
And this is the second chapter, entrenchment. The transaction constitutes an entrenchment mechanism. In real time, before Sigma announced the proxy contest, Vision's board of directors believed that a transaction under which Delta would obtain control of the combined entity was not in the best interest of the company. And then after Sigma announced in February 2026 that it had acquired a 9.1% stake and they intended to replace 4 out of 7 directors, all of a sudden the board instructed the CEO to renew the discussions with Delta, to approach them with an, quote, open mindset, and then unanimously approved the transaction granting Delta the control it required. The only change that occurred between Vision's board's first decision and its second decision was Sigma's emergence and the threat to the director's tenure. There was no change in the market conditions, no change in Vision's business condition, no change in the quality of Delta's technology. It is therefore clear to us that this was not a transaction entered into for the benefit of the company, but rather a transaction intended to secure the board seats. Moreover, Vision's transaction with Delta does not really provide a solution to Vision's business difficulties. Vision's main difficulty is that it is unable to develop next generation systems. Delta's Red Eye is based on radar technology just like Vision's Car Eye. Delta does not provide Vision with the technological leap it needs. It is therefore clear to us that Delta was not selected in order to address Vision's business difficulties, but to address the desire of the directors to keep their seats. Under the rulings of the Economic Court, Judge Ronen in Payne case, sections 26 and 27, and under Delaware law, where directors use mechanisms designed to preserve their positions on the board, and the desire to keep their seats was the dominant consideration, as in our case, the enhanced scrutiny standard applies. Moreover, the transaction here bears all the hallmarks of a merger transaction. Nevertheless, the board chose to characterize it artificially as a JV, all in order to avoid the need to obtain shareholder approval. And again, Matrat Mizug versus Ultrashape, where a board deliberately structures a transaction so as to avoid the need to obtain approval from the general meeting, the court should review the transaction under the enhanced scrutiny standard. The claim of Vision that the joint venture structure was intended to provide a creative solution to the dispute over the issue of control is incorrect. The joint venture structure does not resolve the dispute over the issue of control, but rather decides the issue of control in Delta's favor. The claim of Vision that the transaction does not formally prevent the election of Sigma's nominees to the board of directors or the sale of Vision is misleading. The transaction severely undermines the effectiveness of these actions. Even if Sigma replaces members of the board of directors, the new board will inherit a company whose core asset, CarI, has been licensed exclusively for 20 years to an entity controlled by Delta. Although Sigma can formally sell Vision, the transaction with Delta significantly impairs Sigma's ability to pursue such a sale.
Vision attempts to rely on Paramount Gold and Facoa Industries to argue that the transaction does not constitute an entrenchment measure. However, neither decision supports Vision's position. First, Paramount Gold involved a royalty agreement adopted in connection with the merger, one that allegedly may have discouraged competing bidders. It bears no similarity to our case. There, the royalty agreement was not adopted in response to a direct threat to the director's tenure. Here, it was. In addition, the alleged harm in Paramount Gold was also far more limited. At most, the royalty agreement was said to make competing bids slightly less attractive. Here, by contrast, the board surrendered control over Vision's principal asset. Most importantly, the transaction in Paramount Gold was submitted to shareholder for approval. Here, the transaction was deliberately structured to avoid a shareholder vote. That distinction alone defeats any meaningful analogy. Second, in Facoa Industries, the plaintiff argued that the board had acted to entrench itself through various transactions over the life of the company. But there was no concrete or immediate threat to the director's positions like the one we have here. In addition...
Idan, I'm taking down my role as the moderator to let you know that you have to, your time is up. So you'll have 5 more minutes later on to respond, but 20 minutes.
We are just, would like to
you can finish the sentence, but
okay.
It should be like a short sentence.
It is 3 sentences, but the judges will determine on this issue. Thus far... Thus far, we have established that the enhanced scrutiny standard should be applied. We would like to explain why the company's actions do not satisfy the enhanced scrutiny standard, but maybe we'll do so in the next phase because time is over.
May it please the court, Rochelle Silverberg from Wachtell Lipton on behalf of defendant Vision. I will address the factual basis underlying this motion and plaintiff's unical argument, and my colleague Ted Mervis, also from Wachtell Lipton, will cover plaintiff's remaining arguments. Beginning first with the stipulated facts that govern the motion. The company was struggling, facing significant business challenges. The board acted proactively, as it should, to address those issues. The directors evaluated the situation. They considered a range of strategic alternatives, and they determined that a transaction with Delta provided the best option for the company going forward. All of that happened before Sigma appeared on the scene. Delta and Vision then engaged in prolonged negotiation of transaction terms. Those negotiations, according to the stipulated facts that formed the basis of this motion, then stalled, as merger negotiations often do. At no point was the deal rejected by the board. It was not abandoned by the board. There was no decision by the board not to proceed with a transaction with Delta. The negotiations ebbed and flowed, as merger negotiations do, and they were stalled over this one issue, namely the management team that would run the company. During this pause in the negotiations, Sigma appeared. It announced a 9.1 stake in the company, an intent to run a proxy contest, and the desire to sell the company. After that announcement, Vision and Delta bridged the gap in their negotiating positions and finalized an agreement. They would create a joint venture that combined technologies of both, thereby providing the same strategic benefit originally identified by the board. Yes, the structure of the ultimate transaction was different than the transaction previously discussed, but the transaction at bottom provides the same strategic benefits identified by the Vision board during its many months-long review. Sigma now seeks a preliminary injunction to enjoin the Delta transaction pending a full trial on the merits. In other words, they want this court to delay and potentially jeopardize the Delta transaction, which right now is the only transaction on the table, so that Sigma can run a proxy contest, and if they win, they can see if they can find a buyer for the company that in their view provides a better alternative to the shareholders. In order to prevail on their motion, Sigma must show, first and foremost, a likelihood of success on the merits. They cannot do so. Starting with the fiduciary point and plaintiff's argument that the joint venture fails Unical's heightened scrutiny standard. The first prong of Unical tests whether there is a threat to corporate effectiveness. That test is very easily satisfied here. Vision is suffering significant business challenges, a lack of competitiveness, a deteriorating performance. Its stock is trading at a 70% discount to its IPO price. Sigma cannot seriously dispute that the company is facing significant challenges. In fact, that is the predicate for their desire to run a proxy contest and their interest in selling the company. There is also a threat of delay in the Delta transaction. There is a risk that delaying a Delta transaction for a multi-month proxy contest, followed by a multi-month sales process, would jeopardize the current Delta deal or jeopardize the current terms. The board already conducted a lengthy strategic review. The Delta transaction was the best, Delta was identified as the best strategic partner. No viable buyer surfaced during that process. Moreover, no buyer proactively approached Vision about a deal, despite the company's depressed stock price that would make it a potential takeover target. Indeed, to this day, Sigma has not identified a potential buyer, even though that has been an issue in the briefing, and notwithstanding this very public litigation no one has surfaced to express interest in buying the company. If a Delta transaction was put on indefinite hold, pending the outcome of the proxy contest, as plaintiffs argue the board should have done, there was a real risk that Delta would have walked from the transaction or done an alternative transaction. Or Delta could have tried to renegotiate terms after a failed sales process if the company's position continued to deteriorate or if the company was left in a weakened position due to a publicly failed sales process. Finally, there was a risk that Sigma, a hedge fund looking for a short-term gain, would sell the company at an inadequate price in order to realize a short-term profit. The joint venture also satisfies the second prong of UNICAL, that the board's action was reasonable in relation to the threat posed. The joint venture agreement addressed the company's business challenges without interfering with either the proxy contest or a potential sale. On the question of whether or not it in fact would address the business challenges, again, based on the stipulated facts, that was a decision made by the board before Sigma even appeared. The shareholder vote here is not affected. There has been no change in Vision's shareholder base, no change in shareholder voting rights or the number of directors. The date of the annual meeting has not changed, nor have the requirements for director nominations. Plaintiff does not dispute any of this. Similarly, the joint venture does not prevent a future sale of the company. There is no change of control provision or any other provision impacted by a transaction. And there is no claim that the company did not receive fair value in the joint venture or that the joint venture in any way diminishes the value of the company. Plaintiffs offer various arguments to rebut these basic points, but none bear out. First, plaintiff argues that the joint venture was approved primarily for entrenchment purposes rather than to address the company's business challenges. That argument is factually wrong and inconsistent with the stipulated facts. Again, it is undisputed that the board identified Sigma as a value-adding transaction partner before Sigma appeared. Plaintiff argues that the board rejected a Delta transaction, that the transaction was a non-starter, and that the board determined not to proceed with Delta until Sigma appeared. Again, not accurate. Though the discussion stalled, as merger discussions often do, at no point did the board conclude that a Delta transaction was not a value-maximizing transaction for the shareholders. Next, plaintiff argues that approval of the joint venture improperly impedes the effectiveness of the stockholder vote, relying on the Delaware Supreme Court decision in MM Companies. But MM Companies addressed an entirely different situation. There, a potential acquirer nominated 2 candidates to a 5-member board. In response, the board expanded the members to 7 and filled those vacancies. In that context, the Delaware Supreme Court found that the franchise was impaired because electing 2 directors to a 5-member board is different than electing 2 members to a 7-person board. That went directly to the shareholder franchise. The impediment that plaintiffs argue here is of an entirely different nature. They do not argue any impediment on their ability to get to the board, their power on the board, their role on the board. Their only impediment is that it may become harder to find a hypothetical future buyer for the company. And again, unlike most cases such as this, there is no other candidate on the horizon here.
So maybe you have another 7 minutes and Judge Rosen wants to ask a question.
Okay.
So I'm completely convinced that if we stay in the realm of UNICAL, right, then your analysis is accurate, and under paramount time, you're not supposed to bring it to a shareholder vote in order to protect the long term. I still have 2 questions, though. One is, under Williams, with Justice McCormick, if this is not a takeover, but rather an activist hedge fund, the burden is higher in the sense that a clear day is not enough. We are not a clear right in order to establish a threat, but also, at least in the Williams case, what you said is you need to really point some facts that suggest that this activist is really short-term focused in order to be able to use the same defensive mechanism against him. And the second question is, why is this not also a Revlon situation in the sense that...
I'm sorry, what situation?
Also a Revlon situation in the sense that this is a transaction that doesn't involve money, it involves only stock, but still the main asset is going to a new venture where there is a controlling shareholder that is a new controlling shareholder that is going to control the main assets. So why doesn't this move us from the paramount time situation to the Revlon situation? And in that context, if you can talk a little bit about the alternative, which was Horizon and the AI potential, why this wasn't like a viable option to consider.
Okay, so let me start with Revlon, which was not even argued. We do not believe Revlon. Understood, but I just want to, I believe that Revlon does not apply here, and I believe that the plaintiff does not believe so because it was not argued. But Revlon, focuses on whether or not a transaction is in effect an end event for the company, whether it's a sale or whether a breakup is inevitable. And neither situation is involved here. Vision still exists. The shareholders of Vision still exist. The shareholders of Vision are now participating in a joint venture that combines certain of their assets with certain Delta assets. Well, but in QVC, the company was sold to a controlling shareholder, and the court found that that was, in effect, an end event for the shareholders because they have lost the ability to receive a premium transaction. So in QVC, the question was this a change of control such that the shareholders were entitled to receive a premium? And Revlon applied. And there, the court said that even though it was a stock-for-stock transaction, because Sumner Redstone owned, I believe it was 92% of the acquiring company, even though the Paramount shareholders would continue to own shares in the combined company, they would be a minority, they would lose the ability to get a future control premium, and they were in fact selling control of the company without a Revlon process. Here, the shareholders can still benefit from the company. The company is still owned by a widely dispersed group of shareholders who collectively have the right to elect directors, and I agree with the comment made by the court before, that far from being an entrenchment device, if this is not a good transaction, it increases the likelihood that the directors will get voted off the board at the coming shareholder meeting. But here, the company is still owned by a widely dispersed group of shareholders. There is no controlling shareholder, and there remains, as the court noted in Time Warner, the ability for the shareholders to receive a control premium down the line. And I know that we're probably running over, and I know that I'm sorry, do you have... I know that Mr. Mervis wanted to address some of the voting in Israeli law. Thank you.
Thank you, and may it please the court. I have to say, time out. I wanted to know how to say, may it please the court in Hebrew. So I asked 4 litigators at 4 different firms in Tel Aviv, how do you begin? How do you say, may it please the court? They all gave the same answer. Why would you want to say that to a judge? In any event, back to the argument. On both the fiduciary issue just discussed and the stockholder vote issue that I'll try to address directly, I think there are 2 overarching important points to keep in mind. My clients, the division directors, were elected by the stockholders. No one elected Sigma. Sigma is self-selected. The vision directors have an unremitting fiduciary duty to do what's best for the company and its stockholders. Sigma owes no duty to anyone. They can exit at any time. As Professor Goshen points out in the article we cite, activists don't have to eat their own cooking, even unlike bidders. So I think the answer to the Williams case is that courts should be less deferential to activists than to actual bidders. Second point, substantive law being secreted in the interstices of procedure. The famous comment made by Sir Henry Maine in 1883. That's important here. There's been no discovery, no factual record, no testimony, no chance for your honors to look the men and women on the vision board in the eye. And yet my friends pressed the court to make a finding that the directors acted solely or predominantly or in the main motivated by entrenchment, to brand them as faithless fiduciaries, even though a majority are concededly independent. And on that point, I'd suggest that Judge Moskowitz's decision in BioView is quite important. The teaching of, BioView versus Levy. The teaching of that case is that a plaintiff seeking a preliminary injunction needs more than naked allegations. The court, quote, found acceptable the defendant's position that it needs cash and would also harm the bidders, who are innocent third parties, since there's no claim that they colluded with the incumbent directors. In Levy, the court so held and rejected a 278 argument, even though the directors had delayed a stockholder meeting and used the time that they got for themselves to do a deal with a third party to give 5% of the shares with the potential for 20% more with no stockholder vote. And yet the court indicated it should exercise, quote, judicial restraint as to business decisions made by elected directors, and understandably was reluctant to infer that the directors acted to keep their seats. And that is the centerpiece of the plaintiff's position here. On the other stockholder vote arguments, the merger argument, there's no mention, there's a definition of merger in the company's law that goes unmentioned in Sigma's briefs and in their argument. On the 271 argument, I'm a big fan of Delaware. I yield to no one in my admiration of Delaware. But to simply import a statutory provision from the Delaware General Corporation Law to Israeli law, that I submit is a bridge too far. It's one thing for judges to look to Delaware cases in crafting fiduciary duty doctrines. That's the court's province. The Knesset has told us when stockholders get to vote and when they don't. It's not an accident that there is no sale of substantially all the assets in the company's law. That's not a mistake. It's not a gap to be filled. So I think, as the court indicated by its questioning, it comes down to personal interest under 278. And there, I submit, there's simply, besides no evidentiary basis, what's the right policy here? On the one hand, you have an independent board's entitlement, indeed its duty, to fulfill its duty as unremitting, and the duty cannot, I submit, be subjected to the desires of every individual stockholder who might disagree with the board's business judgment, and I credit that Sigma disagrees with the board's business judgment, and that's its right. But can it threaten a proxy fight and then simply cause the board to put pencils down? Before Sigma appeared, no one would argue that the board needed stockholder approval to do the JV. For months, it worked on the JV. No one said anything about a stockholder vote. The mere fact that Sigma appeared in the midst of the negotiations, the board has to suddenly say, whoa, stop. I can't go further. I can't close. I can't sign the deal. I have to have a stockholder vote. What's Delta going to do? Just hang around? Unlikely. We don't know. But that is, I submit, way too much power to give to every single shareholder, particularly when this stockholder remains free to urge a sale, run a proxy fight. There's no evidence that the JV makes a sale more or less likely. There's no evidence that the JV makes the proxy fight harder or less hard. And that's why I think Judge Ronan's opinion in Payne is instructive and maybe even decisive. Payne doesn't mention 278C. Payne instead was a very creative application of UNICAL beyond the takeover defense context in which it was written to a proxy fight, to the issuance in that case of 24.9% of the stock in the middle of a proxy fight where it was accepted that there was no liquidity need. If 278C meant what my friends say it meant, Payne, I submit, would have been a much different decision. You could have easily have said, well, personal interest. The personal interest, I submit, that 278C is talking about is not the interest that everyone has in keeping their position, keeping their seat. And this is the first time in my life I've made an argument seated.
Ted.
That's a joke. I'm sorry, my time is up.
As you know, yeah, we are in Israel, we keep time. It's not unlike Delaware, we keep time. So you'll have 5 more minutes later, but now we have to move.
Okay, thank you very much.
עובד. הזכרתי רק, וזה לא על הזמן של עורך דין אוריון, אנחנו בדיון בצו מניעה זמני. נכנסנו כאן לדיון די מעמיק על סיכויי התביעה. אני רוצה גם לדבר על הרכיב השני של מאזן הנוחות, וגם אני שואלת כבר שאלה, בתור הלקוח שאתם מייצגים, האם סיגמה, במידה ונחליט לתת צו, תהיה מוכנה להפקיד, יכולה להפקיד ערבות כלשהי.
Judge Pliner asked the parties to address also the issue of the balance of equities, since we are in a temporary injunction, and we've discussed in length the issue of the chances of the main claim. And also the issue whether Sigma is willing to deposit a bond to secure potential damages to Vision in case an interim order is granted.
The answer to your last question is positive. No problem. On issuance of an injunction, the balance of equities strongly favors Sigma. Without an injunction, the harm to Sigma will be immediate and irreversible. The transaction will close before the election of the board members, placing Vision's core asset, CAR-I, into an entity controlled by Delta and depriving the shareholder vote of any practical significance. By contrast, the harm to Vision from an injunction is limited. Sigma is not seeking to block the transaction indefinitely. It seeks only a short delay until after the election, so shareholders can vote before an irreversible, transformative change is imposed. In addition, Vision cannot credibly claim urgency. Negotiations with Delta lasted for months. Nothing in the record suggests a genuine emergency requiring the deal to close on the eve of the election, on the eve of the proxy contest. Vision claimed that Delta said any delay would allow it to terminate the agreement. It is unsupported by the facts and should be rejected. As to the issue of applying here some kind of a business judgment rule, Vision argues that the board's approval of the JV agreement resulted from a lengthy and well-informed process and therefore is protected by the BJR, but the facts tell a different story. Before Sigma announced its proxy contest, the board itself did not believe that the transaction giving Delta control of the combined entity was in the company's best interests. So what changed? What changed that suddenly made Delta control acceptable? Vision has no answer. It offers no business explanation for the board's abrupt reversal on the same transaction, and that silence is telling. The correct answer is clear. The board changed course because of the only relevant change in circumstances, which is Sigma appeared and the directors feared being replaced. And one word about the issue of personal interest. I think this was a question which was raised by Judge Pliner. Vision's argument regarding the director's personal interest fails as a matter of law and common sense. Personal interest does not necessarily require a side payment or a classic financial benefit or an economic tie to the counterparty. It is enough that the transaction serves the director's personal interest in remaining in office. That is exactly what Payne holds. And it is exactly what happened here. Sigma announced that it intended to replace 4 of Vision's 7 directors. The board then approved the transaction that would make that replacement largely meaningless. So this transaction does not merely coincide with Sigma's removal effort, it is designed to blunt the effort to remove the directors. And by doing so, it directly serves the incumbent director's personal interest. And not really. I would like to add a few words about the unical test, if you do not mind. It will take me about a minute. Vision argues on the one hand that the transaction with Delta is the product of a strategic move that had taken place even before Sigma entered the picture. On the other hand, it argues that the transaction was intended to address the real threat posed by Sigma. It is clear that these two arguments contradict one another. Either the transaction with Delta is not a responsive measure to a threat from Sigma, or the transaction with Delta is a proportionate measure intended to address the threat posed by Sigma. I would like to add one more sentence because otherwise Idan will kill me in the office. Since 2022, Vision has experienced a continuing decline in the demand for most of its products. This was not a new situation. There was no impediment to waiting until the upcoming shareholders meeting and allowing the newly elected board to examine Delta transaction. The only immediate and concrete threat was a threat to the continued tenure of the board members.
One quick question. If we, first of all, with regard to the argument of Advocate Mirvis that if this was a personal interest for 278C, then Payne should have been much shorter and different. Why should Judge Ronen discuss Unicol at all if there is a personal interest and the majority of the board is tainted? Then we should go to the shareholders meeting. But if that is the case, since we are dealing with, and I think it's not a dispute, an extraordinary transaction, does it mean that every time that there is a proxy contest, it means that every extraordinary decision by the board may affect the contest and by definition requires the approval of the shareholders? Is this your argument that whenever a shareholder would declare a proxy contest, that would immediately create a situation where the board cannot take extraordinary decisions without approving them with the shareholders?
Just a second, answer 2 questions.
It's a really follow-up, but you said what happened. I think another thing happened. There is an activist hedge fund in the stock, and it's possible that the directors genuinely believe that the future of the company in the joint venture transaction that they considered previously now is better than the future under the activist hedge fund, which doesn't necessarily represent the other shareholders. And I think this is the explanation they offered.
And You have 2 minutes to answer, please.
First, to Kobe's, Judge Sharvit's question, it depends on the number of directors who are going to be replaced. Once you are going to replace the majority of the board members, Payne case becomes to be relevant because there is going to be a significant change in the composition of the board.
Yeah, I think what we meant is that only when the majority of the board is facing a threat to be removed, then Section 278C it can be applied. Otherwise, that's not our case.
Thank you. To begin with the balance of equities, as Your Honor suggested, notice that my friend began by talking about harm to Sigma, not harm to the stockholders. The concern here should be harm to the stockholders, not to one stockholder. On this record, there's no reason to suggest that everything will just be fine if we just press the pause button and make the directors go pencil down. And to the merits argument, that indeed, what I'm hearing is, yes, every time a stockholder raises his hand or her hand and says, I wish to replace the majority of the board, all of a sudden the directors are acting under a personal interest under 278C? That's enough? That seems quite strange to me. Balance of equities. What about Delta? Judge Moskowitz in BioView was very careful to point out, what about harm to the bidders, the non-parties, who were innocent parties, no claim that they colluded? Delta's not a party to this case. They didn't bring Delta in front of the court. By what principle can Sigma ask the court to block, to undermine, and potentially kill Delta's contract right to the JV? And beyond that, I think maybe the most interesting question, well, one of the most interesting questions raised is, should personal interest mean the same thing for Unical purposes as it does for 278C purposes? Even if Unical applied because of the idea that directors want to keep their seats, as we all want to keep our seats, a lot more should be required, I submit, to trigger a 278C vote requirement than that. Unical's enhanced scrutiny is not a showstopper. 278C is a showstopper. 278C means the directors are stripped of the power to do what they could otherwise do without a shareholder vote. Why? Because one stockholder declares an intention to run a proxy fight? I suggest that that's a bit too far. And indeed, I did not hear an answer to the question of, if that were the case, why didn't Payne rely on 278C? Payne said you need not just a personal interest, you also need a change in the balance of power at the stockholders' meeting. And there's been no showing, no attempt even to argue today that this changed the balance of power at the stockholder meeting. On the last point Your Honor mentioned, what happens if the injunction is entered and it turns out that it's later determined at trial that it was wrongly entered? How do we protect the rights of the stockholders and of Delta? In Payne, Judge Ronen required a $300,000 shekel bond. Here, a huge bond would be required. This jeopardizes the entire future of Vision. That's the decision that the Vision directors made, the elected directors. Every one stockholder should not have the right to second guess that or to call upon the court to second guess that. Thank you very much.
Okay, now you used to kill the transaction between Delta and also, and look, I read the facts. Delta was in the story from April 2025. They didn't go December 2025. They are here on 1 March 26. So, you know, what will happen if they will wait 3 months? That's all they want to now, first of all. It's only 3 months. And they were in the story, in the situation, nearly a year. And the second question is like, we must also use our common sense. If you are so convinced that the transaction is for the benefit of the company, and I'm sure that that's what you say, so convince all the stockholders, you will be safe. And also the directors will be safe, that after nobody will come to them with a claim, a personal claim maybe. So I suggest you to consider before we go and speak among us, maybe, yes, we'll do a shareholders conference and just, convince them that this is the best thing. They are only 9%, they can vote against and still. Why? Why do you refuse to, or not refusing to consider it?
Understood. I think I would submit the answer to the first question answers the second. I don't know whether Delta will still be here. None of us do. There's a risk that they won't, clearly. If that happens, then everything collapses. Why not have a shareholder vote? Well, if it's not required by law, the directors are not required to. Delaying for a shareholder vote creates the risk that the JV won't happen. If the JV doesn't happen, we know from the facts that the company's in real business trouble. Could we convince the stockholders? Maybe some of the stockholders want a quick sale. That's not their decision. The board of directors gets to set the timetable for the achievement of corporate goals. That power cannot be taken away from them, I submit, merely because a single stockholder says, I want to change a majority of the board. It happens all the time that directors make decisions that affect the future long-term value of the company. And Delaware has said 100 times, public companies are not town meetings. You do not have to call the stockholders together and ask their opinion on every subject. You only need a stockholder vote when the statute says you do. And in this case, we submit it's quite clear that the statute does not require a stockholder vote. Thank you very much.
Okay. Fantastic. Thank you to both sides. I think because lunch is waiting, maybe we'll skip the part that you confirm and just go ahead and decide among yourself and give us the verdict.
טוב, שוב, בגלל שאנחנו קצרים, אני אגיד את עמדתי בעברית, ומסתבר שאני דעת מיעוט. אז שני חבריי ביקשו, ולכן אני אדבוק בנטייה הראשונית שלי. אני לא בעדך, יקירי, הפעם אני, פשוט עורך דין אוריון ממשיך להופיע אצלי, אתה פחות. אבל אני בנסיבות המקרה הייתי נותנת צו מניעה זמני, כמובן שגם הייתי שומעת מצהירים ורואה עוד עדויות ושואלת עוד שאלות, אבל בגדול אין לי אלא להפנות באמת לפסק הדין של השופטת רונן, וגם מטרת המיזוג אולטרה שייפ, אם אתם יודעים, השופט קבוב לא נתן צו והפכו אותו בעליון, והשופט מינץ כן נתן צו. הנדל. ובמקרה הנדון, אני חושבת שיש צבר של דברים שלפחות את סיכויי התביעה מעמידים בוא נגיד מאזניים מאוינות, כשאני חושבת שהנטל עבר לחברה בגלל העניין של העיתוי, שחודש לפני הם לא רצו לעשות את העסקה הזאת, ורק אחרי שהם קיבלו את המכתב, וזה בניגוד למטרת המיזוג ששם זה היה אחרי, פה הם קיבלו את המכתב ומשהו גרם להם לזוז, והחשד הטבעי זה שזה שהם עומדים לאבד את הכיסא. הדבר הזה לדעתי, ואומרת את זה השופטת רונן, בסעיף 49, בבחינת הסיכויים לכאורה של טענות הצדדים ביחס להשקעה החדשה, יש להביא בחשבון את החשש הלכאורי, כי בקבלם את ההחלטה אודות השקעה, המשיבים, הדירקטורים הביאו בחשבון את העניין האישי שלהם עצמם, שלא להיות מודחים מדירקטוריון החברה בשלב זה של הדיון, לא נסתרה הטענה כי העניין האישי הזה היווה שיקול עיקרי ודומיננטי בהחלטת הדירקטוריון, קיומו לכאורה של עניין אישי כזה משנה את מערך הנטלים, ומעביר את הנטל לדירקטורים ולחברה הטוענים זאת, להוכיח את סבירותה של העסקה על מכלול תנאיה ועל העיתוי בו בחרה החברה להתקשר בה. לכן העברה זו של הנטל מביאה עדיפות למבקש, ולכן בסיכויי התביעה אני איפשהו בצד הזה. ואני, לעניות דעתי, גם מאזן הנוחות נוטה לטובת המבקשת. אפשר כמובן שהייתי מחייבת בערובה גבוהה, אבל כשם שדלטה לא ברחה כמעט שנה, אני חושבת שהיא הייתה ממתינה בסבלנות עוד כ3 חודשים, אולי אפילו הייתי מקצרת את הזמנים, ומורה להם להתכנס תוך חודש, ולתת לדירקטורים לשכנע את כולם, מדוע העסקה היא כל כך טובה, אחרי שהם עשו את כל הבדיקות. אני מודעת לטענה הכללית ולאפקט הרוחב שזה יכול לייצר, שהחשש שמובע כאן, שכל בעל מניות קטן יבוא ויתקע מקלות בגלגלים רק באיום שהוא יחליף את הדירקטורים. איך אנחנו אומרים? כל מקרה לגופו. כאן צריך לראות את ההיסטוריה, את השינוי דעה, שהם לא רצו את הג'וינט ונצ'ר הזה, ורק חודש אחרי הם פתאום מסכימים לו באותו מבנה, ואת ההשפעה הדרמטית שיש לו על החברה. החברה הזאת הולכת לשנות את פניה, למשך 20 שנה היא הולכת להיפרד מהנכס שלה העיקרי. אז נכון, צעד קשה, נכון חריג, נכון יכולות להיות השלכות רוחב לגבי כל דיני החברות, אבל בתיק הספציפי הזה אני הייתי נותנת צו.
I'll start with the translation. I'll start with a short translation. Judge Pliner mainly rely on the Payne decision of Judge Ronen, which basically says that you need to show a prima facie personal interest in the entrenchment of the members of the board. So, all in all, I'm trying to summarize and to keep it short. At the end of the day, it's the minority opinion. So that's one leg of the decision. And in addition to that, Judge Pliner believes that the balance of equities leans towards the plaintiff, because if the transaction will delta will not be stopped, then for 20 years the company will be blocked at the same with the same situation. So, anything else to add on? Okay. First of all, I would like to compliment those who wrote the case, because I think it's a very difficult one, and we discussed, at least Judge Pliner and myself, we had the benefit to discuss it beforehand, and we debated about it, and we think it's not. Yesterday he was with me, but it's not an easy one. No, I woke up this morning with. So I really think that I would say as follows. I think that let's put aside 2 of the arguments. 271 of the Delaware law, I fully accept the position of the defendants that we cannot just import one single provision from the law as opposed to rulings of the Delaware court. By the way, similar provisions appears also in New York law, in Nevada law, or other places. Why just Delaware law? Why not that legislation with different provisions? And the more interesting question is whether in states in the US that do not have a similar provision, whether the courts adopted that provision by judicial ruling. We didn't see any precedent to that. And of course, if the Articles of Association of the company would make such a provision, then our case would be much easier if there would be such a condition to get the company is free to add such a provision to their bylaws. The same goes with the issue of the merger. We don't think that it falls within the definition of merger under Israeli law. We are familiar with the arguments about de facto merger in Delaware, but we don't think that this is the case to apply them. We think that generally, and I think that also Judge Pliner agrees to those two issues, we think that generally the company has the right to follow specific procedures according to the law and not be bound by arrangement that do not specifically apply. So the main question that we debated on was the personal interest question, and at least according to Israeli case law, the personal interest must be material or significant one, not just a personal interest. The protection that the JV gives to the directors, if at all, is indirect, as opposed to paying an ultra shape. It does not apply on the shareholders level, it's on the level of the assets. So it's indirect and it's actually weak. There is no structural defenses, no change of balance in the shareholders of the company. In fact, if the decision is not a good decision, it almost mandates that if the shareholders would believe it's not a good decision, that the directors would be replaced. And actually, maybe not just replaced. Maybe the new directors of Vision would decide that Vision should sue the former directors for a bad decision that they took. So I'm not saying that a protection device could not be made by the assets. For example, if the JB would say that Vision would have the majority, but if the directors would be replaced, then Delta would have the majority, that would be a very clear indication that it was a protection mechanism. And I don't think that this is the case. By the way, if Delta, for example, would say that they agree that Vision would have the majority on the JV, would that matter? They would still be locked for 20 years. It may still be a bad deal for the company and in the eyes of Sigma. And I think that when you go to the balance of equities, I did not see any argument that says that the transaction with Delta was not a good transaction for Vision, or that it wasn't with an expert opinion. And also, we have another supplementary. And also one last thing on that point. I think that the argument that Delta should have been joined to the proceeding is correct procedurally. And actually, when we decide an interim order, we should also refer to the rights of third parties, relevant third parties. And I think that the absence of Delta is crucial in this specific case.
So I'll try to be quick. I think the Paramount Time decision clearly decided that with respect to the value of long-term projects versus short-term plan, the directors have the power to decide, and they don't need shareholder approval for that, and shareholders might not have the same ability to assess the long-term projects versus the short-term future, and especially, I think, since there is a hedge fund in the stock, that's even more so in this case. I think I think we do need to address the question of QVC here, because the shareholders remain the shareholder. It's true, the shareholders remain the shareholders and could benefit from the long-term project. However, like in QVC, there is a controlling shareholder, and the question whether this controlling shareholder could deprive the benefits from the other shareholders. Distinguishing it from QVC, I think you're right that it's not the same control as in QVC. Maybe in the contract there are also some limitations on freezing out the other shareholders. And again, there is the issue on the other hand of the short-term activist hedge fund.
So that's the time to thank both sides and the judges for fantastic and excellent case, and from my perspective, both of them win at some point.